students bring their own laptop, they do their own work. We don't know what project that they do, we don't know that what software they use, what technology they use. It's their liability. They are students, this is not university's liability. So they're one of the defenses that many academic institutions take in India about not being in knowledge of any infringement that is taking place. And unfortunately that's taking place in the government of India also, where they take this defense that this may be a personal use of one of their employees. So there we have to tell about some judgments which are put the vicarious liability of any IPR violation to the company. And we again have some judgment which say that if the infrastructure of an institution is used, it is again the liability from of the organization that is providing that infrastructure. So then. Of course, this is a standard use. The fourth point which the defendant takes is that there is already existing a prior art report. There is already a existing mark like this, or there is something. My mark is not similar to the mark that is. So there is a little misspelling there, or the font is different. So this is in case of a trademark. In case of a patent, they will say, "Oh, this was done ages before." Okay, so the patent office missed it, but I am putting these reports to you. So in case of a patent infringement, they will take a prior art defense being there. Lastly, which is very important in Indian context, is the territorial use. There is a lot of dispute happening because, and perhaps it's also a fault of I would say the IPR owners also. Everybody goes to Delhi for filing a case. Infringement, patent infringement taking place in Coimbatore, and now we're facing this in one of the oppositions. We come to Delhi because Delhi courts understand IPR law. They have evolved jurisprudence over decades, and they understand actually the difference between prior art search and infringement reports and claims mapping. They actually understand these terms to come to a conclusion. So every lawyer would rush to Delhi High Court to seek an injunction, and they are very friendly for IPR. So this is something of a systematic problem in India, where only one of the High Court is taking cognizance of IPR. Why don't we go to Mumbai High Court, or we go to Chennai High Court to enforce our rights? So they will come and say Delhi does not have jurisdiction. And so there we have to be very extra, as a lawyer, we have to be extraordinarily clear in our pleadings, the first suit that we file, to say that their infringement can be noticed or has an impact in Delhi. So there's something happening in Coimbatore R&D center, but when the product comes out, it's available in Delhi. So all that is pleading, I know, but at the initial stage, we have to be very careful in our pleadings in advance, so that the defendant does not take that defense in mediation or arbitration. Anyway, these are something generally we have absorbed over the years, that the defendant would take that kind of a defense during the litigation proceedings. Next slide. So this is what the legal framework in India. Of course, I did not cover the Trademark Act and the Design Act and the Patent Act, because ultimately we govern. These are like procedural framework that we have. We have to go either for a Mediation Act, Arbitration, or Commercial Court Act. In 2015, we have had this Commercial Court Act, and we use every available option to enforce our IPR in India. And as I was mentioning, we had more than 300 mediations last year in a law firm, this year in a law firm, which makes it almost every day we are receiving a mediation case in our law firm. And arbitration, and I'll talk about what is the difference, and of course the Commercial Court Act. All these three remedies can be availed. It's not that if you do mediation, you cannot do arbitration, or if you do arbitration. Of course, if you do arbitration, then some part of the Commercial Court Act goes. But you can come in and appeal again supervisory authority over that. So next slide. Mediation is a process where we have assistance from a third party. It's called mediator. He's called a mediator, and that helps parties to communicate with each other. That's what the broad definition. There are rules now. There is a Mediation Act 2023 that has come. In fact, my law firm had given some suggestions also to the Ministry of Law that have been incorporated. So, mediation is something. It's a common word. Like you have two friends fighting on themselves. So you say, okay, why don't you tell us what to do? So it's simple if you say it, but the way to invoke mediation, and it has certain advantages. The next slide will tell you about the advantages of mediation. You actually have to go under the Mediation Act, which is recently come. We used to have mediation before also, but now there is a formal way to handle mediation, especially as I was telling about the jurisdiction part of it. Okay, so we would face a lot of problem from the defendant that I will not come to mediation because there is no jurisdiction, territorial jurisdiction in Delhi to happen. So we would go online to help that defendant to come up, but the fact is, this particular act, the 2023, actually answered many of these questions on territorial jurisdiction, who is an expert, who can actually be a mediator, preferable mediator. Mediator can be anything, by the way. By definition, it means if I trust any one of you and both the parties trust that person, they can appoint him or her as a mediator. So next slide would tell some of the advantages here. Okay. Some of the advantages, and as I said, I prefer this route a lot in my law firm. If there is any issue that my client faces, of course we hear that out, we make a case diary and then discuss it, what is and remedy for us. Until and unless we are going to seek an urgent injunction in the court where the infringer has gone with massive infringements which are visible across different domains, we prefer the mediation route. Otherwise, if you are seeking immediate injunction from the court, I would say, okay, let's go under Commercial Court Act. This is where we get injunction. So, what are the advantages? Of course, it's less time-consuming. Also, you could have few hearings, maybe in a month or two, depending on what the case is. You can resolve the dispute. It's very less expensive for the client. Outcome, if there is a positive outcome where both the parties settle together, you can make it binding in terms of a contract that you enter between both the parties, and that's very important for us. We can then, for future also, their disputes are resolved. If somehow there is no settlement that takes place in the mediation, then the advantage of mediation is all the proceedings that takes place before a mediator cannot be shown in the court. So if I go to the mediation and admit something, no, there was an infringement, but I don't know, my employer did it. So all that happens before a mediator remains there. The proceedings cannot be shown in the court of law. They become. I'm not sure if that happens in Germany.
You can do it. You can make a contract that you can use it later, but nobody will sign it. As normally mediation is absolutely contractual. It is not prohibited, but it could be an implicit obligation that the parties have misunderstood each other. As I would say, the same thing, confidential mediation, which can be used in court, useless.
Yes. So this is how we do it in India. We have an unwritten contract that whatever we say before the mediator, even if we admit something to having committed an infringement, I cannot show it in the court. So that makes mediation an absolutely a good forum to communicate between the parties. So what the mediator does is he makes, and there are experienced mediators. Again, I don't know why this has happened. All the experienced mediators are in Delhi High Court. So everybody goes to Delhi High Court to have these experienced mediators who know about technology, who knows about the opposite side, and they come to a settlement there. Yes, of course, one of the important advantages that the relationship between the parties remain. If you go to court of law, that trust breaks down. So even after the settlement or non-settlement in the mediation, at least parties know each other's position and they respect each other's position. This is what my IPR is, and I am going to enforce it. No, I am not using your IPR. Even if there is no settlement taken place, there is some kind of a trust that has been created between the parties. Again, forum from jurisdiction perspective, it can help preserve privacy and control. As privacy we talked about, but there is also a control over the proceedings. In the court of law, if you go to court directly, you lose your control. The judge decides your next date. The judge decides whether this evidence is there or not. The judge decides the territorial part of it. Everything. The judge decides whether you can withdraw your case or not. Okay? I filed a case and I cannot withdraw it today because you have wasted court's time. There is this much penalty. Here in a mediation proceedings, advantage is everything is under your control. You just withdraw it, okay? And there is no settlement, and we move forward. So I as an individual and as part of my law firm also, I always recommend clients to first have a mediation done until and unless there is some urgency required, and try to settle the matter. Even in our legal notice, we have a paragraph which cites the Supreme Court judgment that because of so many disputes in India, preferably go for a mediation, and we cite that judgment in our legal notice also.
It's voluntary.
It is voluntary. Many times the opposite party even doesn't come.
You can make it, of course, part of a contract where you say at the end, all disputes shall be solved by mediation followed by arbitration according to the rightful rules of mediation and arbitration. I prefer this, and whenever I had a few cases for WIPO, I have mediated them all to death. They never came to arbitration. And this is exactly the big advantage of mediation.
Right. Absolutely.
Any one of the party can initiate a...
Yes, I can initiate. Yeah. Suppose, yeah.
Initiated by the parties.
Yeah.
And either one of the parties, and if the other party accepts, then it goes into the mediation.
Yeah.
But you need somebody who fully agree on that. I think there must be a person who both parties trust. Otherwise, it doesn't work.
Right. Absolutely. There should be a person whom they trust. So, fortunately, we have many judges who have that reputation of knowing the IPRs, and they're retired now, and they will, because of the kind of jurisprudence they have created over the years. So we trust them to lead, and the opposite party also trusts them, if they have a case. Yes, of course.
Is there any panel of mediators or
Right.
with the mediators?
Yeah, we'll come to that, and I understand I have to finish this. I don't know what the time is, but yeah, we'll finish it.
We have still 20 minutes.
Okay, all right.
I'm not the master of
Look at that watch.
Right. Let me keep this here as all right. So next slide, please. What is an arbitration? Arbitration is much more binding than mediation. Okay, it's much more formal. It's not like a court process, but something between mediation and arbitration. So arbitration is mostly there should be a contract between the parties. Okay, there has to be a pre-existing. So most of the licenses that take place, whether it's the software licenses or the technology transfer agreements that are taking place, if you in the defense, people from defense, they have their own arbitration process. If you do a defense procurement, so again, the difference is arbitration are binding. The award that comes, we call it the judgment. In arbitration we call it an award. So award that comes is binding on both the parties. Unlike mediation is much more informal. So award which comes, of course, there are some ways you can challenge it in the court, but there are very less grounds. It's against the public policy, or the arbitrator was, something happened to him in between. So there are very less grounds which you can actually challenge an arbitrator award. This is because at the time of entering the contract, you agreed that this institution or this person should be an arbitrator. So this is what the and as I mentioned earlier, the Arbitration and Conciliation Act 1996 still governs. You can put conditions where the arbitration will take place. Even if there are two Indians fighting among themselves, you can have arbitration happening in Singapore. Okay, so that's what the flexibility that Arbitration Act allows us. You can have a language there. Arbitration will be conducted in Tamil language, or you can put any clause. So if there is a pre-existing clause which defines how the arbitration will take place, should be there's something called now the fast arbitration track, which is you have to finish arbitration in 6 months. So now there is a new clause that has come after the amendment that took place last year in the Arbitration Act. You can say we'll finish the arbitration in 6 months, fast track arbitration we call it. So if you finish it in 6 months and the arbitrator goes beyond 6 months, then he has to have a special approval from both the parties and record the reason why in 6 months it couldn't take place. So these are some of, let's go to the next slide, which actually tells you the advantages. So why I have put question mark here is because of the way the arbitration is also becoming very expensive. It is delaying. I've seen arbitration happening for 3 years. Nobody is there to judge a judge, as they say. So judge will say, okay, 6 months later, and he extends it. Arbitrations happening from 3 years, 4 years down the line, or maybe party going to the court and halting in arbitration. So our experience as and I'm speaking on my personal capacity is I would prefer that we go to court where we get a finality of a decision rather than putting an arbitration clause. But if you deal with government, and particularly defense organization, they always have an arbitration clause there. And the defense procurement contract that I have seen, they will say arbitrator happening in one of their own officers being an arbitrator. So
one of the senior functionaries
exactly.
at Army commander level, senior people, what is given.
So you take it and leave it. All the vendors would sign that, that arbitrator being from Army itself. So overall, I hope the system improves in arbitration. Then I advise my client to have more and more arbitration. So for example, as I told you, we handle a lot of software cases. There is something called a EULA there, End User License Agreement. We can easily change a EULA and say that arbitration, such and such arbitrator will be appointed. And there have been discussions in the past, and not only my law firm but many other participated, and we finally said no, because the arbitration system in India has become so complicated, so many conflicting judgments that have come. Fortunately, I don't know if many of you saw, it was only 2 days back the Supreme Court actually said arbitration contracts may not be stamped. Okay. So there was a confusion till 2 days back that you need to have a stamped contract to have an arbitration done, which is nobody will have that. Nowadays there are click-through contracts. You have a contract on the web. You have international contracts which are happening, people sitting at different places. How could you put a stamp paper at the time when you are having the signatures done? So there was a confusion on that also. So only 2 days back, and it's all in the legal news portals, if you follow them, it says now there is no need for a stamp paper. Arbitration can be invoked without a stamp paper or stamping, which you can subsequently, it's 100 rupees, right? If you see it's 100 rupees stamp paper, the EULA can be executed on. So, so far, this government is extremely proactive in changing some of the laws, but at this point of time, we don't advise our client to put an arbitration clause because we have not, though these are some of the advantages that arbitration also provides, but somehow the system in Delhi and in India has become extremely slow, not reachable to the litigants. And finally, even if the award comes in my favor, I have to again go to court that is interfering in arbitration proceeding and staying the arbitration proceeding on even pleading of a simple ground that it is against public policy. So we got to test that already, but arbitration is one of the ways where you can have your IPR disputes resolved. Another problem is, in a patent infringement case, you don't have a contract. He's just using your technology. He's using your patent. There's no contract. So there's how can you go for an arbitration unless the WIPO proceedings you take care of that. Otherwise, you don't have a pre-existing contract with an infringer who is actually infringing your technology until and unless you have had a TOT, technology transfer agreement with that defendant. So next slide, we will talk about, so I think this is my last slide. It talks about some of the centers that we have. As I said, Delhi International Arbitration. This is till 1 year back, it was called Delhi High Court. So I don't know how many of you have visited that. There is a special building in the Delhi High Court, or a floor that would host a lot of arbitration and mediation. Most of the IPR owners would go to that center in Delhi High Court Arbitration. And now it is called Delhi International Arbitration Center. It's a new name, but that's most popular kind of a center. It has a fees of 21,000 rupees that you pay, and of course per hearing of an arbitrator that you pay. And you can start, anyone can start to answer your question. As an IPR owner, I can just initiate this proceedings against the defendant and ask him to come for a mediation. There is a NASCAP Dispute Resolution Center, and I don't see Dr. Pinaki here. He is the founder of that. So we've had some dispute resolution taking place there. And mostly what the advantage is, it's an online. Everything is online. NASCAP, full form of NASCAP is National Association to Stop Counterfeiting and Piracy. NASCAP. Okay. So this is again an online institutions that takes care of it. There is India International Arbitration Center, and there is Indian Council of Arbitration. These two are good, very good institutions.
I have a question.
Yeah.
With respect to the Supreme Court observation, it was said that it is not admissible, but it is at the same time it's not void.
Which one?
The arbitration agreement, unstamped arbitration agreement.
Yes.
What does it mean actually in legal terms?
Sorry, can you repeat what?
It is not admissible, but at the same time it's not void.
Yeah.
That's what they say.
So it means it can be rectified later.
Oh.
So earlier what used to happen, they will say it does not exist. Okay. Void means this agreement court would say this does not exist, so there is no arbitration. Now it means it is void. It is admitted. You can put it. You can have it admitted. You can have it admitted, proved through other sources also. Not necessary that you can pay a stamp duty later on and make it admitted also. Okay, it's 100 rupee stamp paper. You can put it later on also. Why? During the proceedings, you can pay for that stamp paper. So though it is void, but it can be still admitted as an evidence in the court. So that's another advantage of this recent Supreme Court judgment. And these are some of the arbitration center, international arbitration, WIPO, mediation, and arbitration. The last three that I have listed are a little more expensive, so we don't choose them. So in a contract which you have, say you're doing a technology transfer agreement, you can put the name of the institution there. In case of any dispute, mediation or an arbitration will take place in one of these centers, depending on where the party is. Both the parties negotiate during the agreement itself. And yes, of course, if there is any chance that during the agreement negotiations we have this clause, dispute resolution clause, we can put any of the institutions, and you can also choose I will do a mediation but then go in a court of law. So this is another option that, my last slide, sir. Very last slide.
I can find.
Okay.
Are they all arbitrated international centers or online?
Which one?
International arbitration centers. These are online or?
Well, yeah, they have an option. Everything is online these days. It depends. Because it's a voluntary process. The mediation is a voluntary process. Arbitration, many times you can define it. The arbitration will take place in Singapore. Arbitration will take place online. When you are entering into a contract, that's why I tell people even when you are entering into a contract, do get a good legal advice. That if there is a dispute, where will the dispute? Will it be online or will it happen in Singapore? So today only, in the morning before coming, I was finalizing a dispute resolution clause in which the opposite party had said, and we agreed to that Singapore, that's why I put this here, Singapore International Dispute will be decided by Singapore International Arbitration Center, because one of the parties was from Singapore, which was our client. But the arbitration proceedings will take place in New Delhi. Okay? So one party in Singapore, the other party in Karnataka, which was the Singapore party was supplying these PCBs, printed circuit board, to the party in near Bangalore, and Singapore Arbitration Center, and proceedings happening in New Delhi. You understand? You can agree to anything in an arbitration clause right now. So it's the real nature of an international trade arbitration clause that you can actually put during the negotiation. But you lose all that flexibility if you don't put it. Whether it is online or it will happen with what is the venue, what is the language happening. So all that needs to be defined. So that's my final thoughts on the whole arbitration mediation. It's yes sir, you have a question.
I had a question. You said that in one of the defenses he can challenge the territorial jurisdiction. So for example, he takes up a defense, say Delhi does not have jurisdiction, but he subjects himself to mediation in Delhi. Then does he lose his defense? Yeah,
he loses his defense. Because he has, in the contract, in the dispute resolution clause, he said he lives in Bangalore, other party is in Singapore, it's a Singapore international, but he said I will have, because their lawyer was in Delhi. So, you know what is happening at the background. That law firm is in Delhi, so they wanted to Delhi. I said let's have it in Singapore, we take a ticket and go and say, dispute happening. But anyway, so these are the good things that are happening with arbitration. I did tell you some disadvantages that are happening in arbitration, but I don't completely rule out, because everything is controlled through a contract itself. Alright, so these are my final thoughts, and of course we'll interact more. My name is Dinesh Jotwani and I am extremely active on LinkedIn, so anybody can send me a picture.